please?
You may, sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, ma'am.
You may put your hand down. Have you taken any medication yesterday or today?
No, ma'am.
Are you supposed to be on medication you're not on?
No, ma'am.
Any sign of fever, COVID, or other illness?
No, ma'am.
And you had enough time to speak with your attorney today?
Yes, ma'am.
And you've been speaking with him all along and working with him, is that correct?
Yes, ma'am.
Counsel, you may proceed.
Thank you. Mr. Anderson, you understand that because you're the one being accused of committing crimes here, that you're afforded certain privileges that other witnesses aren't. Do you understand that? Do you understand that you could elect to testify in this case if you wanted to? Do you understand that?
Yes.
And if you elected to testify in this case, that you would, in addition to answering my questions, you would have to answer the prosecutor's questions as well.
Yes.
And you understand I can't necessarily limit or control the questions that he asks you.
Yes.
He's obviously limited by relevance and the rules of evidence, the same as we are, but simply because I don't ask you a particular question or ask you about a particular topic, that doesn't necessarily preclude him from asking you about something like that. You understand that?
Yes.
And you understand by testifying, depending on what you say, you could open the door for other evidence to come in against you that has not been presented up until this point.
Yes, sir.
And you understand that the decision to testify or not testify is a decision that you get to make. Do you understand that?
Yes, sir.
And obviously you do so after consulting with me, and I can offer my advice and the pros and cons, but at the end of the day, you understand that you get to make that decision.
Yes, sir.
And we have had the ability to discuss your right to testify or not testify. Is that true?
Yes, sir.
Is it true that we've gone over the pros and cons of that?
Yes, sir.
Okay. And you all also understand that you could choose not to testify in this case if you did not wish to testify. Do you understand that?
Yes, sir.
And that no one can make you or compel you to testify if you did not want to.
Yes, sir.
And you understand if you choose not to testify, the judge will instruct the jury that they cannot hold that against you in any fashion.
Yes, sir.
And you also understand if you chose not to testify, the prosecutor would not be able to call attention to that or argue that in any way in his closing argument to the jury.
Yes, sir.
The prosecutor would not be permitted to argue that you didn't take the opportunity to defend yourself or to deny these allegations. Do you understand he would not be permitted to do that?
Yes, sir.
Okay. And after having all these discussions and taking all these into consideration, my understanding is that you will not be testifying. Is that correct?
Yes, sir.
Has anyone threatened you in some way to get you to make that decision?
No, sir.
Has anyone unduly pressured you in some way to get you to make that decision?
No, sir.
Did someone promise that they would give you something of value if you made that decision?
No, sir.
That's all the questions I have, Your Honor.
So, sir, you've made this decision of your own free will?
Yes, ma'am.
You had the opportunity to speak with counsel as well as your family, and you got all the advice you needed,
Yes, ma'am.
and ultimately it was your decision,
Yes, ma'am.
and you've been satisfied with the representation of counsel?
Yes, ma'am.
All right, so what will happen now, I think we have a motion to argue, but what will happen now is the jury will come in and your attorney will rest, because there's no other witness, is that correct?
That is correct.
Your attorney will arrest. The people have already rested and there's no rebuttal witnesses because there's nothing new here. And then once just so you and I are clear, once your attorney rests, there's no turning back, there's no changing your mind. Do you understand that?
Yes, ma'am.
Okay, are you good with that?
Yes, ma'am.
Okay. The jury, we didn't think would be this far today, so I did order them lunch. It'll be here in probably 15 minutes. I'd like them to at least have their lunch to take with them. So I'm not going to release them till lunch is delivered. It's just a few minutes from now. Can we argue or has there been a decision in regard to aiding and abetting?
Well, Your Honor, I'm obviously going to be opposing it. I was presented with the bench memorandum of law that the people prepared today. I would at least like some opportunity to do some independent research on my own, as it relates to that, topic or issue, so I can be more fully prepared to make a better argument to the court.
Okay, and that's fair. We could do that Monday.
Well, the only problem with that, Your Honor, is this, in crafting a closing argument on behalf of the people, we have the burden of proof. And so we necessarily need to understand as we're crafting that, what all the instructions are gonna be. So, while I realize we could do it Monday, it does kind of prejudice the people if we don't get a decision on it. I certainly understand what Mr. Austin is saying, but this is not the first time council's heard about the fact that we're seeking an aiding and abetting instruction. In the initial instructions that were presented to the court the Wednesday prior to this case, we did indicate in an asterisk portion that we would be seeking aiding and abetting. I did tell Mr. Austin we would be seeking aiding and abetting. The only reason I provided a bench memorandum here today is because I anticipated there would be some sort of verbal motion by the defense, potentially. I don't know if they would stipulate or not, but potentially to object to it. So, I mean, I don't know how much research needs to be done on it. That is the instruction. There is a seminal case on it. If council needs some time,
Well, let me ask you this, council, how much time do you need to review it? I mean, I just reviewed it in the back when I got it. It's not very long and we're all learned in this area, but you do have a right to review it and I guess you
Correct, and
want to shepherdize it. So can you do it yet this afternoon or what?
I could certainly put forth the effort to do that, but if so, I would at least like an opportunity to at least do that and maybe come back later in the afternoon and make that argument if that's going to be the case. It's not the first time that I'm aware that the people were going to be requesting the instruction. That's true. It's the first time that I was presented with a memorandum of law on that I would like the ability to, look at and just do some research in so I can be more prepared to make an argument. And I may come across something that it makes it so that maybe I can't make an argument against it. Wouldn't be frivolous. I don't know, but I would at least like that opportunity as it relates to the prejudicial impact, as it relates to summation. There's going to be, it's either coming in or not. I don't think it's unduly prejudicial to the people in that regard because they can anticipate it. I'm sure there's going to be a section in their summation in anticipation of that where they would make an argument crafted around that instruction. And then if the court rules against that instruction, then I think it would just be as simple as removing that particular argument or that instruction from their summation, just as I would be prepared either way to argue against whether or not the court gives the instruction or not. I would be prepared, and I would be prepared in my summation to make the argument either way, depending on what the court's ruling.
Right, I'll ultimately, for example, if the court does grant the people's motion, it is I don't want to say it's not a separate charge, but it's a separate theory of culpability, which we believe applies in this case, which we've given notice repeatedly applies in this case. But if the defense counsel really needs time to look at People versus Robinson, which is the seminal case on it and the project and the follow, I mean, I guess I don't have a problem with that. I guess what I will do is if the court wants to meet on and agree with instructions Monday morning and have argument on this Monday morning, I guess I can do what Mr. Austin suggests, which is prepare my summation sort of in an alternative fashion if necessary, but to the extent I need time to alter my PowerPoint presentation and all that stuff, I just need the time to do that on Monday morning.
I mean,
Wait just a sec, we can have the jury come at 10 o'clock and do this between 9 and 10. I can tell you, I've read it, and my preliminary ruling will be to grant what the people are seeking. So you need to convince me that the law is not the law as defined in Robinson, and we'll get the citation just so we have it for the record, even though counsel did.
And I think alternatively, if
Yeah, it's Robinson 475 Mish at 3, and that is,
And admittedly, Your Honor, I don't think this is something that would require a great deal of research on my part, but I at least like the ability to do some research on it so I can make a thorough argument to the court. I mean, I would be willing if the court would just grant me some time for us to come back and do that later this afternoon.
You know what, I've listened to Mr. Austin's position on it, Your Honor, and I'm just kind of thinking this through in my head. This is coming at me in real time here. Certainly, the defense knew we were gonna do this. I did provide them with a memorandum this morning. It's not a motion. It's not like there's a notice issue, but I did just do that to assist in making the decision to the extent that Mr. Austin needs the afternoon today or the weekend to research this. Because it is a separate theory of culpability, if in fact there was a conviction in this case and the jury did it based upon an aiding and abetting theory, that issue would of course go to the appellate courts, and I would want counsel to have the opportunity to argue against that instruction because that would be an issue on appeal. So I'm going to kind of rescind my position. Let's deal with it Monday morning. If we can get here at 9 o'clock, we can deal with the issue, and then I'll just prepare my summation accordingly.
yeah, and that makes the most sense. And counsel, based on what I've reviewed, I'm likely to grant it, but you may find something else that gives me pause to think otherwise. So Monday at 9, we'll talk about it. And you have a copy.
Yes.
Did you need an extra copy for your client, or are we good?
No, I think I'm good, Your Honor.
All right, is there anything else we need to address? What about the other jury instructions?
Your Honor, thank you. And the court's exactly what I was thinking. I think, what Mr. Ross and I will do, we can talk today. And I think there are some ones we're probably going to have to add a couple, but I do think largely, other than aiding and abetting, we'll be in agreement. So perhaps as part of that, addressing the 8.1s on Monday, we can also finalize jury instruction. If that gives the court enough time, then we'll go right to closing arguments at that point.
And I think that's fair, Your Honor. I mean, I think likely if it relates to the final instructions, I think we're likely to be in agreement on, I think, the vast majority of them.
Okay, so the schedule will be, jury will be instructed to come here at 10 o'clock. We will work between 9 and 10 to iron out whatever we need to. We will both do closings. The jury will then, after closings and my instructions, it might need a short break, but what I'd like to do is get them deliberating before lunch, even if that lunch is at 1 o'clock, especially since they're coming at 10. Neither one of you are, while you are both very good in opening and closing, neither one of you take 3 hours when you only need to take an hour and a half. So I'm not going to worry about time limitation. I know you both to be very thorough and succinct in what you're saying. So I think we can get through both, along with the people's final word, and then go into instructions and then give them that time to have lunch and deliberate. So that's the best use of everyone's time.
I would agree with that schedule, Your Honor.
That works. Thank you, Your Honor.
Okay, is there anything else we need to address?
Nothing other than the defense will have to rest, and then we'll be finished for the day.
Okay,
I would,
so
I would just bring up that you have an appointment Monday afternoon and I have an appointment Monday afternoon as well.
you,
It's like, I think it's at mine's at 3:50. I think yours is around that exact time too. So if the jury hadn't decided by then, we would probably have to go into Tuesday.
it's okay, so we'll work until 3 or 4. I'll have to look at those appointments, I don't know. I think you're right though, but we can work till.
Because I'd have to leave at 3:30 for mine.
Yeah.
And then I don't know what time
Okay.
you have to leave for yours, but I just wanted to bring that up so everybody was aware that we might have to stop
It's
at
okay,
3
10
something.
to 3 is fine. We still have Tuesday,
Yeah. You want me to get the jury now?
please. Right. This food one?
Yeah, it's on its way.
Oh, good. All right.
All rise.
Thank you. You may be seated. On behalf of defendant. You plan to call.
Yes, Your Honor, we have no proofs to present at this time. We will be relying on the evidence already presented. We rest our case at this time.
Thank you. On behalf of the people.
Thank you, Your Honor. We have no rebuttal case.
Thank you. The proofs are closed in this matter, and here's what we're going to do. We've ordered your lunch. We didn't anticipate it would go like this. But that's okay. You get to take a lunch to go. So it's on its way. Here's the schedule now. Monday, there's some matters I have to deal with Monday. So you'll be here at 10, not 9. And you'll likely work till about 3. You will be given the case Monday. Council has to do closing argument each. And then I have to read you your final instructions, which is one of the things that the 3 of us will be using our time to put together for you. Then, when all of that is done, the closing arguments and the final instructions are given, one of you will be released to go about your business, but not talk about the case. Make sure Brian has your number. He'll call you when there's a verdict, or if you need to come back to have deliberations start fresh. We will work until about 3 o'clock because there's some other matters in the afternoon. And then if there is no verdict before then we would work Tuesday 9 to 5. And it would go that way every day, except for Wednesday because it's a motion day. And so it's a little bit too crazy to have a jury plus all the other things that I have going on. So it would be Thursday 9 to 5, Friday 9 to 5. I tell you that because I think I told you in the beginning, there's no time limit for your deliberations. Now, I've had juries deliberate for 1 hour. I've had juries deliberate for 5 days. I have no idea how long this will take. It's done when it's done. Your verdicts must be unanimous. You need to take all the time you need to discuss all the evidence you've heard as to the counts and then make a decision. And I can't give you any hint of how long that's going to take because I truly have no idea. It's all up to you. So remember, no homework, no talking about this. We'll probably all see you in Costco or the mall or shopping for Christmas or whatever. Again, we apologize. We can't speak to you until after this case is over. No research, no homework, no watching local news. Anything else I failed to remind them of?
No, people have no objection. Thank you very much, Your Honor.
No, Your Honor, thank you.
Thank you. I leave you in Brian's capable hands. Enjoy your lunch. Mr. Crino, just for the record, show that I know the proofs have been closed, but usually we go over the exhibits to make sure they were all entered. And according to mine, you offered all 56 exhibits. There were a couple you cut out and a couple you named separately, but everything that you gave me in your proposed exhibit list was admitted, and then the expert was qualified. So we need to make sure the expert is listed in the jury instructions.
Do you want the expert identify, sometimes we do sort of a generic identification. Does the court prefer like we specify the expertise?
It would be an expert in orthopedic trauma surgery.
Okay, thank you.
That's what my notes indicate.
Yep, that's what we offer, Your Honor. Thank you.
Okay, and that's what she was qualified as.
Yes.
So will you be taking the evidence or are we locking it up.
I just spoke to Mr. Austin, and we are going to be taking our evidence. The physical evidence will be locked. We're going to be taking all the documentary evidence here. Mr. Austin does not have an objection to that, and if he needs to see any of it between now and Monday, he knows to contact me, and he can take a look at anything.
That's correct.
Any issues you have?
No, you're right.
All right. I will see you Monday at 9 and jury hopefully at 10.
Thanks, Judge.